welcome everyone to the What's Next for Indigenous Self-Government in Canada's Constitutional Order, the Supreme Court of Canada ruling on the First Nations, Inuit and Métis Children, Youth and Family Act. I'm Brenda Cossman. I'm the Associate Dean of Research at the faculty. I'll be the chair of today's SNAP panel. So our SNAP panels, as some of you who may have been to previous ones will know, are intended to very quickly bring faculty members together, faculty experts together, to talk about some major new legal developments or legal challenges. And so today we have put together what I think is a really amazing panel to discuss this most recent Supreme Court of Canada decision. Each panelist will speak for about 7 to 8 minutes. We will be proceeding alphabetically, and there is, for audience members, there is a Q&A function where you can type in your questions, and we plan to have time at the end where we can actually get to the Q&A, but feel free as we're going through to type your questions into the function. So in the decision, the Supreme Court of Canada unanimously upheld the First Nations, Inuit, Métis Children, Youth and Family Act as within federal jurisdiction. The Quebec Court of Appeal had recognized an inherent right to self-government in Section 35. The Supreme Court of Canada didn't go that far, but it was willing to uphold the totality of the statute. It leaves many, many, many issues unanswered. And that is what our panel is going to try to address today. Some of those many, many issues that are raised by this decision and that remain unaddressed by this decision. So today we are going to hear from, Professor Jean-Christophe Bédard Rubin. We are going to hear from Professor John Burroughs. We're going to hear from Cheryl Milne, who is the Executive Director of the Asper Center. We're going to hear from Professor Richard Stacey, and last but not least, we will hear from Professor David Schneiderman. So without further ado, I'm going to turn it over to our first panelist, which is Professor Bédard Rubin.
Thank you, Professor Cossman. What I would like to talk about are two, I think, salient features in the decision of the court. That is, how minimalist it is on the one hand, and how old school it is regarding the kinds of constitutional argument that the court uses to reach its decision. So every day, more or less, in the past 14 months, expectations were rising. So of course, the court would issue a landmark ruling, or so it seemed to many people, just like the Quebec Court of Appeal did in April 2022. So many people expected nothing less but a ringing endorsement of a generic right to self-government, grounded in Section 35 of the Constitution Act, and thus constitutionally protected. This, of course, the court didn't do last Friday. So it's surprising then, in some respect, that the court took so long to release its decision. From a realist perspective, it seems that this can be explained, perhaps, simply by the fact that having a decision written by the court requires a lot of internal bargaining and agreement, which most of the time leads on an agreement only on the smallest common denominator. But I think there's another way in which we can read this decision, perhaps a more principled reading of the court's minimalism in this case. It is noteworthy, the institutional context is quite noteworthy, because this was a reference question. That is, a case in which the government, in this case the Attorney General of Quebec, controlled the timing and the framing of the issue. And as far as I know, it was really the first time that issues of Indigenous rights featured so prominently in a reference case, at least since 1982. So for governments, this might have seemed like just a regular run-of-the-mill constitutional litigation, but for First Nations, Inuit, and Métis people, it was anything but regular constitutional battle. So the court's minimalism, I think, is in some respect responding to that institutional context. And it is saying, in a nutshell, that it would not stand in the way of, and allow governments with their direct access to courts, which Indigenous peoples lack in Canada, to prevent or delay the ongoing process of negotiation, innovation, and evolution that is required to implement UNDRIP and for reconciliation more broadly. Now, on the other hand, though, the court's minimalism was also a way for it to say and signal, actually, to First Nations, Inuit, and Métis that their claims are still on the table. The court repeatedly said, actually, throughout the decision, that self-government might need to be decided later, but that this would be done in concreto, that is, in a fact-sensitive way or context-specific manner. In other words, the court is, if it had recognized this inherent right to self-government and had thereby directed lower courts to apply its decision, it seemed that it might have adopted perhaps too abstract a notion of what is required for the implementation of self-government, as if it already knew what the final destination of reconciliation is and the institutional forms that it will take in practice. So by leaving things open, the court allows the creativity of the political process to play out. And instead of imposing top-down constitutional meaning, it leaves it open to lower courts to assess various statutory and institutional innovations that can and will be devised in the future in an incremental way. Which brings me to my second point, which is how old school the constitutional approach of the court is in this case. Not only does it refuse to decide new questions, but what it does, in fact, decide, it does it really in and kind of with the well-known doctrines of constitutional law. Or at least that's how it repeatedly presents its reasoning. It's a very traditional federalism analysis that really looks like what we've seen from this court in recent cases. For example, a recent Impact Assessment Act, a reference on that case. It even says sometimes that it is, for example, trite law that Parliament can bind the crown of the provinces. And yet it refuses to tell us precisely how far the statute actually binds provincial crowns. And crucially, it also adopts a very 19th century understanding of the relationship and roles of the legislative and executive branches to make sense of the affirmation in the Act of the inherent right to self-government. So the court reads this as being binding on the executive, as if really the legislative and executive are two distinct entities, which it doesn't always do in its constitutional cases. But that this affirmation is not necessarily binding on the courts because it is the province of the court to rule on what rights people have. So in other words, it is, in some sense, old constitutional forms at the rescue of new statutory innovations. And I think that this is also a crucial implicit message in the decision. So in doing so, the ruling of the court is some reassurance that we already have the tools that we need to implement UNDRIP. Achieving reconciliation does not require reinventing the wheel or learning a completely new constitutional language. It just requires us and constitutional actors more generally to use the tools that we already have, but to put them to better use and perhaps for better ends as well.
Thank you. I think I'm next. Well, I'm appreciative of this decision because it upholds a statute that was years in the making in terms of negotiation. So many Indigenous peoples from different organizations worked with the federal government to respond to the Truth and Reconciliation's calls to action that said Indigenous peoples need to have greater control, responsibility in relationship to child and family services. And so this act allows for the Indigenous nations to be able to take that responsibility either by directly using it or also because of the coordination agreements that they can enter into with the provincial governments. And if First Nations, Métis, Inuit people enter into coordination agreements with provincial, federal governments, they're given paramountcy, those agreements, over other provincial laws. So there's a lot to celebrate here, and it's going to be very, very healthy and helpful for our children as Indigenous peoples to see the ongoing revitalization, resurgence of Indigenous law, responsibility to rebuild our families with the support of the federal and provincial governments through these coordination agreements. So I don't want to take anything away from it. Now, I'm going to say the structure of the reasons for decision are quite troubling for me, because what the court said is that Parliament can act as if inherent sovereignty exists within First Nations. and they can act as if this sovereignty exists, and they can bind themselves to act in accordance with this presumption. And I think this is what got us into this mess as Indigenous peoples. The Parliament acting as if, or pretending in relationship to what their authorities are on kind of an exclusive basis to be able to proceed to deal with the questions that Indigenous peoples have long been concerned about. So what's my concern here? I'm imagining another kind of act that might be passed by a province or a future parliament that says Indigenous peoples do not have the right to self-government. They do not have that right. And it is the provincial government's responsibility to deal with child and family services, and we will referentially incorporate provincial laws as federal laws. And internationally, international law supports the doctrine of discovery, which it has long done, which shows that Indigenous peoples have a lesser place in the creation of their laws. And if it is the case that Parliament stepped forward or another legislature stepped forward and said there's no such thing as the rights of self-government, that the provincial governments have the responsibility for this field, and international law kind of incorporates a doctrine of discovery point of view, then it may be the case that the court would uphold that, because the court's being deferential to parliamentary sovereignty here and saying, we're not looking at any independent content that Section 35(1) might have. We're not asking the question whether or not there's an inherent right to, we're not answering that question as to whether or not there's an inherent right to self-government. What we're really doing is saying, what is the federal authority in relationship to Indians and lands reserved for Indians? And if the authority is that complete and there's no independent contact outside of what Parliament presumes, then in some ways this decision is a little too cute, too clever, because to attempt to answer this question just by looking to parliamentary sovereignty alone ignores the revitalization of Indigenous law within Section 35(1), and it ignores maybe any independent element of how UNDRIP might impact on and perhaps constrain the federal or provincial authority in this field. The only reason that the federal government is bound here again is because it said it's bound. It can act as if. And for me, acting as if is not enough. There has to be something else that's broader than this, because another legislature at another time might take steps that would allow this. And we've seen like 150 years of this. Parliament acted as if Indians didn't have any, Métis Inuit people didn't have any normative power, aka the Indian Act. And they acted as if they had the ability to deal with the best interests of children, and they sent them off to residential school. They acted as if international law supported them through the doctrine of discovery, and that allowed for the undermining of our relationships with our territories and one another. So, the polarity has shifted now. I like the policy choice that Parliament is making here. I support it. But the court's saying we're not making any broader ruling here in relationship to what that policy choice is. And in another case, another era, another time, these arguments could just as easily support the downgrading and the underwriting and the undermining of Indigenous rights. And I'll just say something quickly about the right to self-government. One of the reasons I think the court didn't want to issue a ruling that said that there is an inherent right to self-government in Section 35(1) of the Constitution, because we have this case from 1996 called the Vanderpeet case, which was supported by another case called the Bavajuan case, that said Indians, Métis, Inuit people only have rights if it was integral to their distinctive culture at a certain time. For Indians, prior to the arrival of Europeans. And in the Bavajuan case, the court held that Indigenous peoples, in this case Anishinaabe peoples, didn't have the right to govern themselves in relationship to economic development, in case gambling, prior to the arrival of Europeans. Therefore, they couldn't claim that right today. The court says we're not ruling about Section 35(1) in this case. There's other cases that are out there. That Bavajuan case is out there, building on the back of Vanderpeet. But when they do talk about self-government in paragraphs 1, 112 and 115 or 114 of the opinion, what did they talk about? They talk about the fundamental culture and identity of Indigenous peoples in paragraph 112. And then in paragraph 114, they talk about Indigenous culture will certainly be a major factor when section 35.1 comes about. To just limit Indigenous rights under section 35 to questions of identity and culture is why the Vanderpeet test was successful and the Modern case was successful in taking rights away or freezing rights for Indigenous peoples. And I worry that if this case comes back to the Supreme Court of Canada and they think about a section 35.1 implication, and they said they're not ruling on section 35.1, they're going to keep focusing on culture and identity because of what they've said here in paragraph 112 and 114. And what's protected in section 35.1 is existing Aboriginal and Treaty rights of the Aboriginal peoples of Canada. It's not just about Aboriginal, what's cultural, what's identity. It's peoples. Peoples have political rights that have meaning beyond just culture and identity. And the court has ducked that and has not signaled in this opinion that when they go back to look at section 35.1, that it's the people's rights that will be accounted for, not just cultural and identity rights. And I'll stop there and I'll turn it over to our next speaker.
Thank you. Thank you very much, Professor Burrows. Sorry, I've gone off screen a little bit because I'm fighting with my screen, fighting with the cats for my screen. Thank you. That was wonderful, both our first speakers. And now let us move on to Cheryl Milne.
Thank you, Brenda. I'm going to make 2 points or focus on 2 areas. The first is the Asper Center's intervention. The David Asper Center for Constitutional Rights did intervene in the case. And I also want to talk about, but more importantly, I want to talk about what are the implications going forward for child welfare and child rights in Canada. So first of all, the Asper Center intervened to support the constitutionality of the Act, of course, and to argue that Section 35.1 of the Constitution Act protects generic self-government rights. And it made 2 arguments. The first was that, or one of them was that if in the event that the court determines that stare decisis governs the question at issue, and that's going back to the Pamodjuan and Vanderpeet cases that Professor Burrows mentioned, that there were compelling reasons that exist to reconsider any of those precedents that would preclude judicial recognition of Section 35 generic self-government rights over, and in particular over child and family services, as it was the focus of the case. There were over 30 interveners in this case. The vast majority supported that position. And I think that this is a case where the court, probably in trying to come up with a consensus decision, basically ignored most of the interveners' arguments. There were at least 2 provinces that supported that argument, BC and Manitoba. Alberta did not. It was it was on the side of Quebec in the case, but there was very little reference to or even acknowledgement of the arguments made by interveners in the case. So they didn't listen to us on that point. The second point that they also didn't listen to us on was reference to the UN Convention on the Rights of the Child, which is also referenced in the preamble to the Act as one of the motivators in Canada's obligations and the under that treaty, as well as the international criticism that Canada has come under for its egregious record with respect to Indigenous children in child welfare. Having said that, what I want to talk about now really is about what this act, now that it is fully constitutional, means going forward. And I think that to some extent, the judgment really gives us a lot of really good language about what the federal government is being held to and what the provinces are going to have to do. So I understand. I mean, I hear Professor Burrows' concerns about the legislation, and I share them. But there are also some groundbreaking aspects of the legislation. Firstly, the purpose was really recognizing the legacy of residential schools and the harm, including intergenerational trauma, caused to Indigenous peoples by colonial policies and practices. There's a really strong emphasis throughout the judgment acknowledging that. Also, that Parliament recognized the disruption that Indigenous women and girls have experienced in their lives in relation to child services, and the importance of reuniting Indigenous children with their families and communities for whom they were separated in the context of the provision of child and family services. And that's from paragraph 5 of the judgment. The judgment also talks about sort of 3 elements of the purpose, and I want to use that sort of those 3 elements as a way of talking about what may come in the future and what is actually happening now in this area. So there was this openness in Section 8 to using 3 different types of legal norms that are interwoven, and this is the sort of braiding analogy that or metaphor that's used throughout the judgment, looking at both provincial and federal and Indigenous laws as to come up with a scheme that is going to better the lives of First Nations children. So that's a key element of that. But really, the scheme of the act was also has 3 separate elements, and the judgment looks at or categorizes the provisions according to this scheme. So the 3 categories are: first, provisions affirming the right of self-government that we've heard about. The second are the provisions establishing national standards, and these are going to have some very significant implications for First Nations and not just for the provincial and federal governments. And the third is the provision setting out the concrete implementation measures. And so those are the 3 categories that the court used to analyze whether or not, analyze both the pith and substance of the act and as also the overall effect. But first I want to talk about the affirming self-government. A number of First Nations across Canada have already utilized the legislation to exercise their right to self-government in the area of child welfare. For example, in Ontario, the Wabesimong Independent Nations, Treaty 3, have entered into a coordination agreement. It was the first in Ontario. There are many others. I'm just using it as an example. That entered into a coordination agreement with the federal government, the provincial government, and the First Nations, and outlining the roles and responsibilities and ensuring that there was financial support for them to assert their self-governance role in child welfare. A bill in BC, Bill 38, supports self-government. Ontario, there were amendments to the Child, Youth and Family Services Act to make sure that elements of this legislation were incorporated into provincial child welfare legislation. But a note of caution is that there is a fine line between jurisdiction and offloading. And so that any these coordination agreements require support and resources. So you can't, and even if a First Nation really wishes to engage in and become self-governing in this area, it's really clear that they need the support. And part of that is that this jurisdiction doesn't offer a quick fix to the issues that ground the legislation, and that is the trauma that First Nations communities and agencies are dealing with on a daily basis. There's a need for infrastructure and support through resources and communities of practice. So that's just sort of a note of caution. The other is the national standards. So the provincial legislation has, in many cases, already embraced the standards. Ontario has incorporated it. Many other provinces have incorporated, particularly the description of the best interests of the child standard that is much more expansive, that it really does incorporate many elements of the cultural needs of First Nations children, and it has been applied in court cases across the country. So it's including, so most courts have said that when a First Nations, Métis, or an Inuit child is the subject of a child protection proceeding, that these standards that are set out in the legislation apply, regardless of what the provincial legislation says. In fact, it's they apply over and above what the provincial legislation says. Now, there's general provisions. There isn't the kind of specificity that one might hope, but at least it's there, in particular with the best interest of the child principle. And another example is, there is some debate right now as to whether the provisions also apply in cases of more private guardianship. The Manitoba Court of Appeal refused to rule on that issue, but there's an Alberta case that applied it to private guardianship issues, so beyond just a child protection agency, so that there may be some expansive and knock-on effects of this. And then finally, the last is the implementation measures, and that the negotiation, it says negotiation is preferred to litigation, but there is this flexibility that the court acknowledges with respect to provinces, and there are issues or concerns that the provinces will not actually embrace it as they should. So I'll stop there because my time is up, and if there are questions, I can expand further. Thanks.
Terrific, thank you. And let me just remind the audience that you can put your questions into the Q&A. You can type them in there, and our panelists will get to them after. And so next we are going to, if I can go through the alphabet properly, I believe that next we're going to Professor David Schneiderman.
Right. I am next alphabetically. You introduced us in a different order, but happy to proceed.
That's because I was still working on my alphabet back then, but now the Sesame Street has kicked in, and I think I got it.
Excellent. Thank you. So I'm going to take a different tack than others, maybe speaking in some ways, in ways that Jean-Christophe was speaking of the case, but also wary of Supreme Court decision-making along the lines of Professor John Burroughs's argument. We should stipulate, of course, as he did, that the Supreme Court of Canada has not been good on self-government, and that the intervention of Parliament in this particular instance is welcome. And so I'm going to take that as a starting point to think about the reference as contributing an entry point for legislation in contributing to what I call Canada's constitutional culture. And when I speak about culture in these terms, I'm not talking about a museum and artifacts in the way that the Supreme Court does in Vanderpeet and its progeny, but rather I'm talking about the ways in which Canadians, not just courts and even not just politicians, but Indigenous communities, NGOs, the media, in which we all understand the Constitution to have defined meaning. And what I read the case as opening up entry points for contributing to the meaning of Canada's Constitution, moving beyond the dialogue model, which really confers on the Supreme Court of Canada the final word. What it does is it breaks down the traditional separation of powers model between the judicial and the political branches, and actually broadens those who participate in the construction of constitutional meaning. So this idea of constitutional culture moves beyond text, moves beyond judicial interpretation to incorporate understandings that are articulated by other participants in our constitutional culture. The taken together, they're an assemblage of arguments that we can make, which renders Canada's Constitution not static, but fluid, and so moves at some moments. For sure, it's static and long periods of time, but also can move in particular directions when actors are listened to, when international commitments are incorporated, like UNDRIP. So I want to suggest to you that legislatures, Parliament in this instance, have a role to play in the construction of constitutional meaning. The Supreme Court takes the lead, or follows the lead, I should say, of legislatures in things like the content of freedom of association under Section 2D, or analogous grounds under Section 15. Legislatures can help direct the ways in which the content of the Constitution will be filled in by the judiciary. And I think that's could potentially be what's happening here. The opening available here is that the Supreme Court of Canada will follow the lead of Parliament in recognizing an inherent right to self-government, bracketing for a moment the paradox of having an inherent right recognized by contingent parliamentary legislation. Quebec, of course, argued that recognizing an inherent right to self-government in the legislation amounted to an amendment to the Constitution of Canada. And this the court rejected, and it's a welcome rejection because the court's taken a very rigid view about the amending formula, describes this not as an amendment, but an affirmation, which doesn't give rise to a constitutional amendment. But in paragraph 81 acknowledges, and I want to quote a little bit from this passage, that the affirmation may in part be viewed as a step toward changing or adjusting the culture underlying the actions of the federal and provincial governments. And this is offered in a pedagogical spirit. Parliaments use the act to communicate to the courts and society its position that the law must recognize the importance of Indigenous self-government in relation to child and family services. Now, the court also insists that Parliament can't command the court to incorporate its interpretation of the Constitution, and instead describes it as a pedagogical function that may, over time, inculcate new attitudes or approaches that will promote a culture of respect, another incorporation of culture in this decision, for and reconciliation with Indigenous peoples. The court acknowledges that it doesn't have a monopoly on constitutional interpretation, that Parliament, it says, has a role to play, and it should have said, so do others. Indigenous communities have a role to play in the construction of constitutional interpretation. It is the case that the executive and legislative branches are applying, interpreting the Constitution on a daily basis. And it should be acknowledged that Indigenous communities are doing the same thing in the exercise of an inherent right to self-government, and they too can contribute to the meaning of Canada's Constitution. There are passages in the decision that are still troubling. The court describes itself as the guardian of the Constitution, and Parliament can't bind courts, that courts have the last word, particularly around the doctrine of paramountcy. Judicial construction and paramountcy is applied in this case to displace provincial laws that are inconsistent in their operation with Indigenous community legislation around family and child services. So I would have preferred more humility, actually, issuing out of this ruling. But the important thing I want to draw from this is that the court acknowledges that there are other influences and sources of constitutional meaning, and the court is going to take cognizance of the influence of those other sources of constitutional meaning, and thereby pluralizing. And I think it's imperative that we pluralize the sources for the content of constitutional meaning. Why? Because I think we need to run a project really of decolonizing the Canadian Constitution. And in order to do that, I think we need to some extent, displace judicial authority. Thanks.
Fabulous, thank you. I have to say, I'm not used to having all my panelists keep to within their time frame. It's quite extraordinary. Thank you, everyone. And now, in fact, last but not least, is Professor Richard Stacey.
Thanks, Professor Cossman. Thanks, everyone. Well, it is just a coincidence of my name that I'm going last, but I'm going to end with what I think is a hopeful and optimistic reading of the case, while recognizing, of course, that what Professor Bédard Rubin noted about the minimalism of the judgment and what Professor Burrows noted about the concerns that the judgment raises. I think I'd like to make two comments about why the judgment is obviously to be celebrated. Let's put that on the table. It's excellent that this decision by Parliament has been upheld. And the points that I want to make are to emphasize that, at least for now, the right to Indigenous self-government is in a good place, taking into account what Professor Burrows said a second ago. And then the second point that I want to make is that I think this judgment, there is a reading of the judgment that it is moving, that the court and the law is moving inexorably towards the recognition of an Indigenous right to self-government, an inherent right to self-government in Section 35. And this, I think, is just another step in that direction. So let me start by just reiterating what it is that the judgment does. So it doesn't affirm that there's a constitutional right to self-government, but it does recognize Parliament's authority to say that there is such a right and to act as if that right exists. But in doing that, what the government has done, the court emphasizes, is make a promise to Indigenous peoples that it will act as if Section 35 protects an inherent right to self-government. So the question is, why is that important? And I think it's important because it does allow Indigenous peoples, again, for now, to sidestep the obstacles that the 1996 cases, Van de Piet and Pomajawan, have thrown up to the recognition of Indigenous self-government. Now, it was certainly one of the more ambitious arguments that the interveners made at the Supreme Court, that Van de Piet should be revised, or at least Pomajawan as a kind of specific application of the Van de Piet test should be overruled. That clearly didn't happen. And indeed, at the same time, the court didn't obviously affirm or recommit to Van de Piet or Pomajawan. There's very little reference to either of those cases in the judgment. So in some senses, the door to overruling those cases, or at least substantially revising them, remains open. But nonetheless, even if they remain good law, and even if it is the fact that in light of those two precedents, Indigenous peoples would have to establish through the arduous test of Van de Piet that they do have an inherent right to self-government, for now, the government has allowed them to sidestep that, right? So while those negotiations or court cases go on, right, through the Van de Piet test, the government has said to Indigenous peoples, let's us proceed as partners as if the inherent right to Indigenous self-government exists. And that's good. I think there's a lot of room for progress as long as this commitment is in place, and recognizing that provinces or a future parliament might walk that back. For now, there's a live and realistic opportunity for significant advancement in the field of Indigenous self-government. The second point that I want to make builds from an almost glancing reference to the honor of the crown that the court makes in somewhere in the middle of the judgment, paragraphs 60 or so. And it says that in making the promise to Indigenous peoples that they will act as if the Indigenous right to self-government exists, the government, the court says, has intentionally embarked on a particular path to reconciliation. And later on in the same paragraph, that this engages the honor of the crown. So I just want to say a few things about what that actually means. What is reconciliation? What is the honor of the crown? So in a number of judgments over the years, the court has said, almost truistically, that the honor of the crown is a duty that the crown bears to act honorably in its relationship with Indigenous peoples. That's not very helpful. So what does that actually mean? the court says the honor of the crown bears this duty as a result of the special relationship that exists between the crown and Indigenous peoples across Turtle Island. What is that special relationship? That special relationship arises from the fact that when the crown or settlers arrived in Turtle Island, they asserted sovereignty over Turtle Island, notwithstanding the fact that there were already Indigenous peoples acting as sovereign across Turtle Island. And the mere assertion, the unilateral assertion of sovereignty by the crown, did not, as a matter of law, extinguish Indigenous sovereignty. The political, legal, cultural, and linguistic arrangements that Indigenous peoples had lived under for years continued to exist as a matter of law. As a matter of fact, as we know, it became very difficult for Indigenous peoples to live according to those government and legal and linguistic structures. Nonetheless, what the court has recognized is that the continued existence, the fact that Indigenous sovereignty survived the crown's assertion of sovereignty, is what gives rise to the special relationship. The honor of the crown is the court's recognition that the crown has a duty to act in recognition of, and to some degree in mitigation of, the unilateral assertion of sovereignty over pre-existing and unextinguished sovereignty across Turtle Island. And that the honor of the crown manifests in a number of distinct duties. So the duty to consult and accommodate while Section 35 rights are being negotiated, the duty to act as a fiduciary in certain circumstances, the duty, and this is relevant for our purposes today, the duty to act diligently to fulfill promises that the crown makes to Indigenous peoples. These are all manifestations of the honor of the crown, ways that specific duties emerge from the honor of the crown. But in all of these cases, in this line of cases that talks about the source of the honor of the crown and how these duties fall out of this broader honor of the crown, what the court has recognized throughout is that the objective, the motivating or animating principle of the honor of the crown is reconciliation. And at that point, I think we can ask reconciliation of what? And this judgment, along with a handful of others from the last 15 or 20 years, indicate that I think what government is working to reconcile is the reconciliation of sovereignties in present-day Canada. The sovereignty that the Crown unilaterally asserted and the sovereignty of Indigenous peoples that survived that assertion, the Crown's assertion of sovereignty. And so reconciliation of sovereignties, recognizing an Indigenous right to self-government, is part and parcel of that project of reconciliation. And if you recognize that this is, I think, the subtext of this judgment, if you read the judgment in such a way that the honor of the crown is based on the reconciliation of sovereignties, then I think even the affirmation of the government's decision to recognize and to act as if there's an Indigenous right to self-government is consistent with the view that we are jurisprudentially moving towards the reconciliation of sovereignties and what I think is an unavoidable recognition of Indigenous self-government in Canada.
Fantastic, thank you. As I say, in what might be unprecedented of everyone having stayed within their time, we now have some time for questions. I encourage the audience members again to type their questions into the Q&A function. You can do so anonymously, so you don't have to be shy. And we have a few questions that I will now put to our panel. So one question that came from the audience was, what kind of case might lead the court to opine further on the content of Section 35 along the lines of Professor Burrow's wish for expansion beyond culture as the central concept for the content of Section 35 rights? So maybe we could go to you first, Professor Burrows.
Sure. So the work that's happening on the ground, as Cheryl mentioned, is leading to all sorts of examples of Indigenous peoples using their own laws and then finding them be harmonized with provincial and federal law in a way that implements the Declaration on the Rights of Indigenous Peoples. And there will be a challenge to some exercise of authority in relationship to what Indigenous communities are doing in implementing that law. And it may be that that will tee up opportunity, particularly when the exact exercise of the power is without the coordination agreements. The legislation does allow, and binds the Crown to recognize Indigenous peoples exercising their sovereignty just through self-assertion. And if law is happening on that ground, it's going to be challenged whether or not that goes beyond the act in the particulars of the way the First Nation is acting. So perhaps it will arise in that way through a dispute under a particular case as a First Nation is exercising this power, or Métis or Inuit group.
Does anyone else want to say anything about that one?
Can I just add something that struck me as I was rereading the decision yesterday? I realized that there's actually no mention of Vanderbilt in the decision of the Supreme Court at all. Actually, they cite the case once when they're summarizing the opinion of the Quebec Court of Appeal. But it's really surprising that a Court of Appeal is willing to overrule a precedent and go that far, and yet it doesn't generate the kind of such a strong criticism from the Supreme Court that you might expect if they don't follow the lead of the lower court. And I think not citing Vanderbilt in the opinion, I don't know what they're doing, but maybe they're suggesting that there's some room to maneuver there with regard to what kind of test should we apply for Aboriginal rights under Section 35. I have no idea, but the fact that they're not relying on the case as kind of grounding their opinion in this reference seems to leave another door open.
Anyone else on that one? Okay, so there are lots of questions coming in now. So could Professor Burrows or others comment a bit more on how the Supreme Court of Canada drew on the UN Declaration for the first time, and what promise or issues this might raise going forward?
So what the court said is that the Crown is bound by the Declaration because the Crown bound itself by the Declaration. In other words, through positivistic law, it said that this declaration applies to the federal government and the provinces in relationship to this Child and Family Services Act. And so the implication for this going forward is that there is this possibility in other acts that the Crown would do the same. So in British Columbia right now, there's a debate about the implementation of the declaration that would amend the land transfer acts and the land acts. And people are worried that that would undermine their property rights in the province if the declaration is being implemented through the act of the legislature recognizing Indigenous peoples can form agreements with the government to change how land is related to in a Crown land sense. So to make this a little bit simpler, if the Crown implements the declaration, the court finds that that is sufficient to bind the Crown for those purposes.
Anyone else want to comment on?
Yeah, just a couple of things to note that the implementation of UNDRIP in British Columbia and federally is, as Professor Burrows mentions, potentially controversial. And this enactment probably is a good model for moving forward for implementation purposes. Although the UNDRIP, if incorporated and applied to federal law or to British Columbia law, has a potential of substantially disrupting the status quo, particularly around free, prior, and informed consent that limits Indigenous rights and title. So this is a difficult terrain to navigate. So we could take the reference as an instruction or instructive about how to move forward in implementing UNDRIP in more specific ways, although the expectation is, I think, that it will infiltrate Supreme Court decision-making in various ways, and maybe it's something we should hope for. Again, I'm advocating for the pluralization of the sources from which we draw content that fills the Canadian Constitution. And UNDRIP seems to me to be as good a source as any for helping to further the project of decolonization of the Canadian Constitution.
Great. So we have a few questions that deal with questions of Supreme Court of Canada supremacy and parliamentary sovereignty. let me see if I can sort of try to put these together a bit, which is, in the decision, for example, is the Supreme Court implying or saying that Parliament is the ultimate and highest level of sovereignty? What if international law and judicial bodies interpret it going in different direction? And then similar questions around how Supreme Court supremacy, if that is what it is asserting, how is that consistent with Indigenous self-governance? So I put that out to whoever might want to jump in there.
Well, I'll begin. I talked a bit about the Supreme Court preserving its role as guardian of the Constitution and resisting the idea that Parliament can bind the court about what the Constitution means. Again, I would have preferred a little more judicial humility about the role the court plays in defining what the Constitution means, beyond, one might say, the particular dispute that's before the courts. So it goes some distance in some of these passages to say that it still reigns supreme, despite whatever Parliament might say. Yeah.
Anyone else on that one?
I'll just add one thing, which is the hypothetical situation that Professor Burrows raised. So it's clearly true that while Parliament has bound the Crown in that sense with this statute, Parliament is not bound by its previous proclamations, right? So Parliament is not bound to have this statute exist in its current form in perpetuity. It could obviously change its mind. I think the interesting question would be, were it to do that, right? Were it to say, we're actually not recognizing a right to Indigenous self-government, I think that raises the opportunity for a constitutional challenge, right? And the challenge would be, well, actually, Section 35 does protect an Indigenous right to self-government, and now, by Parliament walking back its recognition, it's acting as if there was one, that's unconstitutional. So in some sense, the Parliament hasn't bound itself, but it has painted itself into a bit of a corner. Were it to change its mind, I think that opens the door for a constitutional challenge in ways that aren't really possible in other situations, right? In other situations, the claim has to be that government has acted in such a way that does violate a right, that does something that prevents people from doing a thing that is protected by a charter right or a Section 35 right. But in this case, all the government has to do is change its mind about whether it recognizes the existence of such a right as part of Section 35, which is just a sort of unusual setting in which a constitutional challenge could be made. And if that happens, then I think that dynamic between the court and Parliament would come to the surface. And I think the court has to some extent reminded Parliament that it is the ultimate interpreter of the Constitution in ways that I think are prescient of a possible future challenge in this regard.
And so I think the point I was trying to make is to say that might not be true, because if Parliament has the final word about what it can do, it can walk back without any limitations, because there's nothing constraining it from a Section 35 perspective. International law is not constraining it. Inherent right to self-government is not constraining it. The Parliament can act as if, and what the court is upholding here is what the Crown is acting in relationship to. And so if it had another policy choice, I like the way you're reading this, Richard, and that honor of the Crown method might open up a door for an argument to have some hearing that could lead to success. But on the straight reason of the case, I just think that there's no constraint. There is no check and balance on Parliament here. The Parliament gets to do what it says it wants to do. Yes, in relationship to the court cases, but the court cases here, the court's saying there's nothing in Section 35 that we're saying yes or no about self-government. And so, you can imagine other instances that aren't just in this field where the Parliament acts as if, if it has jurisdiction over it, 91 whatever, an area, that's the moon's green cheese, or we want to pretend that this can happen or that can happen. This as if acting can be a pretend kind of way of going about legislation. And I worry about the pretendy way of acting when there's not a constraint that is pulled from a pluralization that David's talking about.
Which lends me to think about treaty. I mean, isn't that the way in which we should be moving forward? It's reliance on the Canadian Supreme Court to lead the way, I think, is wishful thinking. They might make some incremental moves. A generic right to self-government might already be present through Aboriginal title, right? You can't manage uses to which land will be put without making those kinds of decisions through some kind of self-governmental mechanisms. But it seems to me it calls upon us as all of us to think about how we might move forward. And I think the idea of new treaties or national treaties, and I'm hearkening back to debates during the Charlottetown Accord about third levels of government, that this reference provides an opening, I think, to reflect on other avenues for achieving self-government rather than simply relying on 9 justices, in this case 8, on the Supreme Court of Canada.
All right, we are now at 1:29. So even though there are quite a few more questions in the queue, I think at this point I am just going to thank our panelists. I have to say that listening today, I learned an enormous amount about this decision, and again, the extent to which it raises more questions than it may answer, and questions for the future. So let me thank my colleagues. This is now just in the not alphabetical, the order in which they appear on my screen: Professor Stacey, Professor Bédard Rubin, Professor Burrows, Professor Schneiderman, and Cheryl Milne, for leading us through this really quite wonderful discussion. And thank all of you for joining us today. And stay tuned for our next SNAP panel.